It is now my pleasure to welcome Ivanna to the stage. So come up, stage, podium. Ivanna's personal injury practice is focused on representing survivors of sexual assault, childhood sexual abuse, sexual harassment, revenge porn, invasions of privacy, and institutional abuse. Ivanna is a compassionate, practical, relentless lawyer and a fierce advocate. She hopes that in assisting survivors in seeking justice and closure, she can help them find their power again. And Ivanna will be presenting on the topic of the therapist as expert witness, reports, and testimony. So welcome.
Thank you very much, Brenda. Okay. Well, it's not just short girl problems, it's medium girl problems too. Okay. So hello and good afternoon now, everyone. For those of you who haven't heard me introduce myself, my name is Ivanna. I'm one of the associate lawyers here at Gluckstein Lawyers. So today, I thought it would be important to present on the topic that a lot of healthcare providers may have come up in questions when they're supporting survivors, especially as survivors are going through any version of a justice process, whether that's criminal, civil, administrative. It could be a college proceeding. It could even be something like an internal investigation at a university or at an employer's office. Sometimes, or LTD applications, so long-term disability applications. Sometimes medical providers need to become involved in the process for a number of reasons, a little bit of which I'll go over, but as I'm sure a lot of you in the room and online have experienced, especially when survivors need things like diagnoses or treatment plans, or when there's a request from someone like an insurance company, a judge, or a lawyer to understand not only the scope of a potential disability or other mental health challenges somebody is going through, but also to help substantiate that, in fact, what the survivor says happened actually did happen. And I'll get a little bit into that as well. My presentation is a little technical and a little focused on expert witnesses, so reports and testimony is the topic. So it's our hope that we can provide some practical tools to the healthcare providers in the room in the event that they do have to support a survivor through the justice process. If I could have some AV assistance, thank you. Thank you. Okay, so the overall framework here is to understand who can be a quote-unquote expert. There is only a specific type of expert that can be called in witness as an expert witness to give testimony. Allowing expert evidence, so this is the kind of evidence that a qualified expert is allowed to give. I have here participant versus litigation expert. Sometimes we know them as treating professionals versus independent assessors or independent experts. Reports, so this is some practical tips on what could be included in reports, how to format them, and so on. And finally, actually providing testimony in a judicial or quasi-judicial setting. So first, who can be an expert? So an expert is a person that's qualified by the court to provide an opinion in order to assist the judge or the trier of fact in arriving at a conclusion. So experts can only give opinions. This is an important fact to remember because at the end of the day, in our justice system, what's known as the trier of fact, be this a judge, an adjudicator, an administrative hearing officer, anything along those lines, they're the only ones that can actually make legal factual determinations. And what that means is the trier of fact is the only one that can actually say, legally speaking, somebody experiences a disability or somebody has a diagnosis in the context of the judicial system. And so an expert is actually there to provide an assistive opinion to that trier of fact. Part of the reason that we have qualified experts as the only experts that can give testimony is because the court or whichever quasi-judicial body, I'm going to use the word court, but I don't just mean a court when I say that. I also mean a hearing or college proceeding, so on and so forth. But for simplicity, I'm going to use the term court. When an expert is providing testimony in court or is providing an opinion to the court, what they're doing is they're assisting the trier of fact in coming to that conclusion. And the way that we make sure that the opinion is, so to speak, a legally useful opinion is by qualifying the expert to speak on certain topics. So it's a really complicated roundabout way to say we don't want a podiatrist talking about a neurological issue. It's the same thing. So experts have to be qualified in a certain field to give certain specific opinions to assess the trier of fact. And it has to be more than just helpful. So this is kind of a nuanced issue. Helpful specifically means something that the judge can use, or again, a trier of fact can use to form the basis for her or his opinion. So helpful can be saying, for example, this person experiences symptoms of anxiety. But something that's more than helpful is to say, I've done this sort of testing and I've arrived at this sort of conclusion, and it would be my opinion that they experience something that falls within this DSM-5 diagnosis criteria. Acquired special or peculiar knowledge or skill is typically required in order to be qualified as a court expert. So this can be education, but this also can be life experience or other sort of practical training. So as my last point there says, advanced education is not a precondition. So what kind of expert evidence can an expert actually give? So there are what we know as the common law criteria for admissibility of an expert, or otherwise known as the 4 factors we have to look at to determine if somebody can actually say something. So the first is it relevant? I think we all have heard this term before. Relevant means, does it actually mean anything to the underlying issues of the case? So a good example of this would be, for example, let's say somebody comes into court and there's actually a question about whether or not they have a substance abuse issue. Obviously, evidence about, for example, do they have drugs? Do they have criminal charges about drugs? That might be relevant. Whether or not they get parking tickets might not be relevant because that has nothing to do with drugs. And that's quite a trite example, but it can get much more technical, and there can be a lot of fights about whether something's considered relevant. Necessity is another big one. Necessity means that a trier of fact needs these facts in order to come to a conclusion. So another example there would be, if this person experiences symptoms of anxiety, for example, they can't make decisions at work or they're crippled by decision fatigue, this might be a necessary fact for the trier of fact to find out in order to actually come to the conclusion that the person has anxiety. It may not be necessary to know that the person really doesn't like driving, but it could be, depending on whether or not that's actually another symptom of anxiety. So the exclusionary rule prohibiting its admission, i.e. oath helping, that's another kind of legalese thing. What it means is you can't give extra evidence to help a judge come to a certain decision. Basically what it means is you can't give like kind of repetitive type evidence. And then lastly, a properly qualified expert, so impartial, independent, and unbiased. What that part means is you aren't allowed as an expert, an independent expert, to take on the role of an advocate. And this is a fine line because as healthcare providers, it's, I think, a universal mandate that you want the best outcome for your patients. In these circumstances, though, technically the duty of an expert, especially an independent expert, is technically to assist the court. And so technically the court is the ultimate client in this case. So even though you may want the best outcome for the patient, your responsibility actually lies with ensuring that there's independent, so to speak, unbiased evidence before a judge, for a judge to come to the correct, so to speak, conclusion. If you cross the line into advocacy, an example of that would be to say, this person it's my opinion that this person requires this sort of treatment plan, and they would benefit from let's say, 5 years of therapy twice a week, and they would benefit from a PTSD treatment program. That's not advocacy. But an example of advocacy would be to say, I've now written to CAMH and asked CAMH to admit them to their program. So that's where you cross the line from unbiased expert into an advocate. So here we get to the difference between a litigation versus a participant expert. So a litigation expert is an expert typically hired by a lawyer or an insurance company or an adjudicative body, College of Doctors, College of Physicians, and they have duties, as I said before, to the court or, as I said before, other sorts of bodies. So the College of Physicians, College of Psychiatrists, College of Social Workers. They must comply with, in the civil courts, Rule 53, which is the formalized rules we have in our civil courts that say that you have a duty to the court to provide an unbiased opinion without advocacy. Participant experts, or sometimes also called treating experts, these are the ones that are involved in the day-to-day treatment for patients. You still have a role as a participant expert in a civil or quasi-judicial type proceeding. It's just different. Your testimony is considered, in fact, lay testimony, because what you're actually talking about is your day-to-day or treatment experiences with the patient. That's a different kind of assistance that's offered by the trier of fact or to the court, because you're saying, it's my experience that we tried Cipralex at 5 milligrams, it's not working, then we tried 10, it is working, so it's obvious to me that this person has some kind of hormonal imbalance. That's evidence that a judge still needs to hear, but that's not, so to speak, an unbiased opinion, legally speaking. So because it's not an unbiased opinion, participant experts don't have to abide with the rules for unbiased independent opinions, so you can continue to refer your patients to CAMH if they need be. And both litigation and participant experts are required to give expert opinion only inside their area of expertise. So again, if you're a neurologist, you're giving an opinion about how the brain works. You really shouldn't be giving an opinion about whether or not the spine's misaligned. So this is, I actually just talked about this a little bit. So it just means this is the kind of evidence that a treating expert is allowed to give. So I don't know if everyone can see all of the text. It's quite a lot of text on there, but basically it's limited to your observations and your education, is what I just said. So qualified experts can rely on reports from participants and non-party experts. What this means is an independent expert, so one hired by the court or by the lawyer or by an investigator, are still allowed to rely on and make reference to reports or notes made by non-experts. And so this is important for any treating professionals in the room to know, because if you're helping a survivor or supporting them through the justice process, it's important to recognize that at some point, a lawyer like me is going to call your office and say, I need your complete clinical notes and records. And in those clinical notes and records, what I need to see is I need to see a complete history of not only mental health, but also of any disclosures that the survivors made to you about issues that they've had, and in particular, any disclosures they may have made about whether or not they were abused or experienced sexual violence. And this is extremely important, not just for me to see, but it's important for the expert, the independent expert that I may hire on behalf of the survivor to see. And even more so, it's important that the defendants or the Crown or whoever is on the other side of the table see especially things like disclosures. One of the challenges I'm sure everybody in this room is familiar with is ensuring that survivors are not only believed, but also that the scope of the impact on the survivor is also something that's clearly understood. So to have those notes about disclosures and then to have a really good mental health history saying, this person reported today that they felt anxious, even if you're not prescribing something, even if you're not sending them for testing, even if you're not doing a referral, just having those notes in those records can be a huge help to say, look, this person has been experiencing anxiety for 10 years, even if they haven't gone to therapy, even if they haven't had medication. It just bolsters and encourages, in a very strong way, all the parties involved in the process to believe not only that what happened, but that the survivor's lived experience of what happened to them is also something that's true. And for the expert, they're entitled to rely on the notes that you may make as a treating professional. And they're actually allowed to use that kind of evidence to explain why they may have come to their own conclusions. So it helps them to say this person has a history of 10 years of anxiety, even if, again, we don't have, for example, a prescription history that goes back that far. So a quick note about how people are called before a court or a quasi-judicial body. So you could, as a treating professional or as an expert, be summoned to give testimony. So a summons means that not only are you yourself required to show up in court, it can also mean that you're required to produce certain clinical notes and records, notes you may have made, therapeutic notes, or any sort of other documentation or records that you may have produced. The privacy laws still apply in most of those cases, so you may still have to go through and get the patient's consent before you disclose these records. There are, I'm sure no one will be surprised to hear, court mechanisms that will circumvent that process if necessary. But more often than not, you will say, can I have the person's consent? You will receive an authorization and consent, and then it will be disclosed that way. And if there's no consent from the person, then a court will decide whether or not records should be produced. And if you have to proceed to court, or if you have to give testimony before any kind of body or an investigator, it's encouraged that people review their clinical notes and records before they give testimony, especially to make sure that you have, for example, dates correct, dosages correct, medication lists correct. So on to reports. So if you're called either as an independent expert or as a participant expert to provide a report to, again, an investigator or a lawyer, there are a couple of things that will need to be produced in that report in order for it to be helpful for the survivor. So the first thing that you would receive is you'd receive a communication either from me or from another lawyer or sometimes an investigator setting out the framework. So what your obligations might be if you're an expert or if you're a participant expert, key facts that I need you to identify, what issues I need you to address, and specific questions I may need you to answer. So a really common question I always ask is this person suffering from any mental health challenges? And where do these mental health challenges stem from? Can you identify the root causes of these mental health challenges? Typically, most of my clients are experiencing significant mental health or psychological issues. Sometimes I may ask for an opinion on somatic related issues or physical issues, but because we have to stay within the scope of your practice, while you can comment on your observations about physical or somatic issues, typically if I have an issue, for example, with a digestive tract or pain, I'll seek a gastroenterologist or like a neurologist to comment on those specific portions and provide opinions and diagnoses and treatment plans there. A lot of lawyers will communicate at first through an engagement letter, but thereafter with a number of phone calls. And the phone calls will help everybody understand what some of the needs are, what some of the specifics are, and what any unique challenges or issues you may face might be. So for example, if I have a client that has a history of childhood abuse, and they've come to me and they've said, I'd like to sue for sexual violence that I've experienced as an adult, one of the things I want to call the expert about, and I want to make sure the expert's able to pull apart what is the consequence of the childhood violence and what is the consequence of the sexual violence. And obviously, I don't have to tell anybody here, that's a very difficult distinction to make, but that is something that I would want an expert to be alerted to. I certainly wouldn't tell the expert which way to jump. That is within your scope, that's not within mine. But I'd want to understand how you understood that and how you would go about pulling that apart. A note as well here to say, if you ever produce a draft report for a lawyer, those draft reports could be subject to disclosure. So when I say could, not often do they need to be produced, and there is a high standard, a high bar for whether or not they can even be requested, but there are times where they could be requested. So that's to keep in mind when you're producing a draft report. This is something that the opposing side, so especially if you're a treating expert, the opposing side may get a view of this. So just keep in mind that while we work to maintain confidentiality and while there are rules that protect it, not all written communication can necessarily be protected. It's just an example of what improper conduct means. So this is the test I was talking about. So this is where the other opposing side in, for example, a civil or a criminal proceeding, these are some examples of, or these are some things that they would be allowed to use as a basis to ask for production of things like draft reports or engagement letters or any written communication between an expert and another lawyer or an investigator. Basically, the idea is they have to have some reasonable belief that somebody did something improper. So for example, I told you what to say. If they find out that I told somebody what to say and you wrote down what I told you what to say and you didn't do it for a good, like there wasn't a basis, you hadn't done testing, that's improper conduct. It's not my role to tell you what to say. Not that my boss would like to remind everybody and all the lawyers out there from other sides, I don't tell mental health professionals or experts what to say. I ask them very nicely to please tell me what they want to say. Okay. Part of a report typically includes your own curriculum vitae as well, outlining your experiences, your areas of expertise, and any other education, training, and employment history you might have. This is something the court typically requires in order to qualify you as an expert, so we just put it in the report. So here are some reasons why we would need an opinion. So the first and primary reason that we ask for it is to substantiate a patient's damages and causation. So damages are a variety of things in the law, in the legal world, but they break down to what are the effects that have happened to a survivor as a result of, for example, sexual violence. So this is to assess for pain and suffering, loss of income, which typically means an inability to work, either prior to the date of the assessment or going forward from the date of an assessment. Care costs, so this is ongoing need for therapy, treatment programs, perhaps they need extra massage therapy, perhaps they need medications. And opinions. So a causation opinion is a legal term that is the legal term for what I was talking about earlier, which is how do we say this mental health challenge is a result of this underlying trauma. So part of the opinion we may ask for is for you to, like I was saying earlier, pull apart what caused what challenge. Another reason we ask for reports is to understand the nature of patients' reactions. So what that means is, as we know, survivors have a variety of reactions to experiencing trauma. Some of them repress their memories, some of them deny that it happened, some of them take responsibility for things that were never their fault. And so we need sometimes a supportive opinion to say, we understand that this is a normal response to trauma, and it doesn't invalidate the fact that they went through trauma. And post-traumatic stress reactions. So sometimes we may need an opinion to explain why somebody, instead of fighting or flighting, froze or did the freeze or appease, why they engaged in safety mechanisms, why they didn't report, why they didn't take themselves away from an abusive situation. Thankfully, we've been moving away from these sorts of what we call rape myths, but they still exist. And sometimes we need an opinion to support the argument to say you can't make those arguments anymore because psychology and science has come far enough that we recognize that these are responses to trauma and not indications of something ridiculous like consent. Oh, yes. So the last one that I had there was precursors to testimonies expert. So I'll get into that in the last section, so I'll just skip past that for now. So drafting a report. So what is needed specifically in the report? So in order to draft the report, you as a treatment provider, either as a participant expert or a litigation expert, need a couple things from me or whoever else might retain you. So specific referral questions. So this is, as I was saying earlier, questions like what sort of mental health challenges does this person have? What's the treatment plan? So on and so forth. So I would provide you with all the relevant documents you would need to come to that conclusion. So it would be, for example, clinical notes and records of other healthcare providers, any school records or employment records we could obtain. I've put here plaintiff and defense discovery transcripts. So that's specific to a civil proceeding typically, but it could also include criminal proceedings and sometimes some administrative proceedings. These are records of testimony that a survivor, witnesses, and potentially the abuser may have been created from their testimony they've given. Workplace Safety Insurance Board, CICB and ODSP records, also any LTD, STD, other medical health type records, and CICB opinions and decisions as well. Other expert opinions, so like I was saying earlier, if I needed a neurologist to come and speak, you would receive a report from that neurologist saying, there's chronic pain and I think it's stress related, if that's what they wanted to say. The contents of the report after you receive all of that is first to identify your assessment procedure, so what the purpose of the assessment is, and then to identify yourself, so your qualifications, education, training, experience, etc. We also like to have a quick record of each examination, when, where, how long it occurred, and a description of the information obtained and the source of that information. So from the interview, from a social history, from a medical record, from hospital records, so on. Then we typically ask you to provide a short history of the survivor's underlying history and the current situation, so that we can have a clear understanding of what you understand and the factual basis for the assumptions and conclusions that you've come to. Psychosocial history of the survivor prior to the sexual assaults. And we recognize that a large number of our clients are survivors of childhood abuse, and so as much as possible in those cases, but we understand if it can be limited in some cases. A brief history of the sexual assaults, finding from psychological testing if employed, So this is specific to if you've done any sort of psychological testing using mechanisms or specific psychiatric assessments. Okay. The immediate and long-term impact of the sexual assaults, including, and this is a non-exhaustive list of the things that we like to see. I think, yeah, there's a very long list. So it starts with theoretical overview, description of experiences, so on and so forth. Thought there was a second slide. Oh, there. Whether or not they experience substance abuse, peer relationships, sleep disturbances. So this is all to say, this is a list of some of the specifics we want, but it's not exhaustive because we all know that sexual violence, child abuse, they affect a whole person. It's not just you, it's not just your suffering, it's not whether or not you've experienced drug abuse. It's also how you relate to other people. It's also how you trust authority. It's also whether you even seek medical treatment. It's even whether you believe that you should get on the bus this week because maybe the bus driver is somebody you can't trust because he looks like your abuser. It's significant and it's pervasive, the effects of this kind of violence. And so while we've given a long list of examples here, it's non-exhaustive, so we leave it sometimes open to the treatment provider to say, look, I've observed that this person can't bathe properly because abuse happened in a bathroom. And so they lose their jobs because they simply can't show up in a groomed and bathed fashion at work. It could be as discreet as that, or it could be as broad as this person can't leave their house. And then lastly, we would ask for any DSM diagnoses if you're able to provide them, and if you want to, treatments you prescribe, and prognosis. My boss is right here. That's right. CYA. And then ensure the report is organized and thoughtful. This is a note that we receive from especially judges. Judges are, and other administrative, hearing officers, whatever, they have such limited time to go through these opinions. So one of the most helpful things that can actually be done is, aside from the content being, structurally sound, obviously, if it's organized in a thoughtful manner with a number of headings, a judge is actually more likely to read something with a lot of headings and with something like an executive summary and a 1-paragraph treatment plan and a 1-paragraph prognosis. And that's not, again, to tell you what to do, but just to let you know what judges like. Okay. And then as to testimony. So if you're called to give testimony in front of a court, the first thing that happens is this thing called a voir dire. A voir dire is a preliminary sort of assessment done by the hearing officer to determine whether or not you can actually give testimony in open court as a qualified expert. The trial judge is the one that determines the procedure, but typically, you go on the stand, they ask you questions about your qualifications. Sometimes they may ask you questions about the scope of the evidence you're going to give. Sometimes they may question you on any report or notes you may have produced, all of which is used to determine whether or not you are qualified to provide the opinion that you want to provide and whether or not that opinion is relevant and therefore admissible. Here's how it happens. It's a long process. I'll need to demonstrate, the lawyer will need to demonstrate how your opinion fits within the test of admissibility. That's my responsibility. I'll also take you through your curriculum vitae, emphasizing relevant qualifications. And whether or not you've been accepted as a court by as an expert before, whether or not you do work for, so to speak, both sides. So, Crown and defense, or plaintiffs and defendants, or in, college and complainants. You'll have to sign a quick form that says, yes, I acknowledge that I have a duty to be unbiased and assist the court, not be an advocate. And then I will ask the court to qualify you as an expert, and then the judge gets to decide whether or not you can give testimony as an expert. The slide on bias, I was tempted to put up something from the Johnny Depp defamation trial because I feel like that expert was basically cross-examined on bias for 3 hours. So bias is a real significant issue, though. So bias is a thing that says that even if you're qualified, even if you have all the right experience, even if it's within your scope to give the opinion, if you have some personal either challenge or personal benefit that you would gain from having an opinion go one way or another, you're not an independent, unbiased expert. So for example, if you do work 95% of the time for one insurance company, chances are good that you want to keep doing work for that insurance company because they're paying you to be an expert. And so you have a financial incentive to have an opinion that they like and not one that they don't like. The presumption there is you can't give an unbiased opinion if you're motivated to keep giving an opinion that they like. Because typically when you give an unbiased opinion, sometimes you have to tell people stuff they don't like. Obvious other things would be like family relationships, or if you assume the role of an advocate. These circumstances are rare, that you would be qualified as an expert but then disqualified due to bias. And the judge at the end of the day has the ultimate responsibility. And then if you get called and if you qualify as an expert, then you get to prepare for trial. My responsibility or other lawyers' responsibility would be to make sure that you've seen everything that's going to be produced in the trial and to allow you to read all the transcripts and other expert opinions if necessary. Typically, I'll want to do a dress rehearsal, question and answer. So this is a dress rehearsal both of the examination in chief, where you give your qualifications and you give your expert opinion, and then a dress rehearsal of the cross-examination, where you're cross-examined on things, again, like bias, qualifications, experience, publications, so on and so forth. Right. The last 2 points there are to advise that any documents that we will need to rely on, so we being you or the lawyers, have to be produced in advance. So if there's anything you find afterwards, for example, you found an old note, you found an old journal, you found, a couple of emails you forgot about, we need to disclose those as soon as possible before the trial, because once the trial starts, it's unlikely, very unlikely, we can add anything new. A reminder that despite us having to disclose all of the evidence beforehand, any draft reports or discussions that we had with you beforehand are not automatically subject to disclosure. In the examination in chief, when you provide your direct testimony, we're going to emphasize your expertise, what you were retained to review, what your opinion is, the foundation for that opinion, which is, for example, not just the evidence that you've collected, but also any sort of studies you've read or texts you've read, studies you've participated in, etc. You are permitted to also comment on the opposing expert's opinion. So if you are called as a treating professional for psychiatric reasons, and a defense lawyer has their own psychiatric expert, you're allowed to read their report and then answer questions saying, I disagree with this testing mechanism, or I disagree with this conclusion because, they ignored these parameters, or so on and so forth. You are allowed to also bring diagrams and charts if useful. Cross-examination is a specific form, so it can also only be asked in a specific form, meaning they can only ask you yes or no questions. I think everybody's probably seen it on television. It's not that aggressive most of the time, but it can get that aggressive sometimes. The purpose of a cross-examination is, as much as possible, either to undermine your expertise or to get you to disagree with your own conclusions or agree with the opposing conclusions. This is something that would require a lot of preparation, and you would receive a lot of preparation from any good lawyers who had retained you so that you would know what to expect and what sort of questions we anticipate. And here's some examples of some difficult questions. There are a lot more. Whoever hires you should prepare you properly. So some tips for cross-examination. Avoid negative emotions like frustration, anger, or exhaustion. It just undermines your credibility as an expert. And I hate to say it, but humans are still humans, even if they're judges. They can't help but not dislike somebody who may be frustrated or angry or irritated. And that's just one of the problems we have to deal with, but we know about it. And presumably any treatment provider is aware of themselves, or should be. And so they know how to do the work necessary to keep themselves in line. But it is helpful to remember that judges unconsciously, even in their best days, can be affected by those kinds of negative emotions expressed by an expert. And remember the context. So your role versus my role. We're working together, but at the end of the day, I have to take on the role of an advocate. You're required as an expert to take on the role of a helpful opinion provider. You can be firm but not aggressive, and be prepared. So this is read everything that you can in advance so that you have things front of mind, so nothing as much as possible can catch you off guard. Keep your opinions within your area of expertise. Even if you have a ton of experience in a different area, if you're not legally qualified by the court to give an opinion in the different area, your opinion as an expert is not admissible in those areas. You can clearly state your own opinions and the basis on which your opinions were found, and to verify your opinions, work with corroboration where possible. Okay. So those are some of the technical elements of being an expert and a treating professional for survivors. I have my last slide here, which has questions, but I wanted to sum up before I get to questions that a treatment provider can be a really powerful ally for a survivor, in addition to the important work that you do with survivors on an everyday basis, on a day-to-day management basis. And so if you're prepared to assist the survivor in the expert process, that doesn't change the fact that you have a day-to-day obligation to them and your other patients. So a reminder that it's basically taking on an extra level of stress. So a reminder to take care of yourself if you do choose to become an expert. Thank you.
Okay, we have time for just a couple questions.
So not everyone has a family doctor.
Yes.
I don't know if people don't realize that, but that's something that comes up pretty commonly with the people that I know. So for those who don't, or maybe have relied on different sources of support, for example, some people are doing coaching, and that's a very unregulated area. So what happens when a lot of the information that's available, that's been disclosed by a person with this lived experience, has been passed on to someone who's not traditionally a person that would come and provide evidence and be that expert? How do you access that?
Yeah, great question. So I think there's a key distinction between litigation expert and participant expert there. So a litigation expert is the one that needs to be qualified. That's the one that needs to have the curriculum vitae and experience and all that stuff. A participant expert can be anybody with enough experience to qualify in that category. So, for example, registered psychotherapists for a long time didn't actually have a regulated body, or I should say psychotherapists didn't have a regulated body for a long time. But you can still get a letter from them saying, I've been doing counseling work with this person, and here are my observations. Obviously, psychotherapists can't provide diagnoses, but they certainly can say, I have observed that this person has symptoms of anxiety or symptoms of depression. I understand they went to a walk-in clinic and got, a bunch of like Ativan or something like that, and that's what helps them sleep at night. So we can access that opinion and those observations in a separate forum, so we can still do it that way. And those records, those notes, whatever they might be, even if a person's going to like a mental health clinic, or if they're going to the local emergency room for mental health services, we can still get opinions, we can still get those notes, and those can still be very helpful.
Thank you, Ivanna.
Great. Thanks so much, Ivanna.
And we're running a little bit late, so we're going to forego the break. Hopefully that's not going to be too impactful for anybody. Our next speaker will be introduced. Ivanna, you're introducing Raven.
All right. But please, if you need to go take a bio break,
Please do.
Yes.
Do that.
But we're not going to take an official break.
Yeah, if anybody needs to take a break, I have absolutely no problem. Please walk while I'm talking.